Thank you, Dr. Lorandos, for that fantastic presentation. And we talked about American courts and how American law has addressed parental alienation. Let's take a trip to Europe. We have three experts today, Dr. Nick Child, Dr. Jorge Guerra, and Judge Marie-France Carlier from Belgium, Dr. Guerra from Germany, and Dr. Child from Scotland. And let's hear from there about their struggles and their opportunities in their jurisdictions about parental alienation. Dr. Child.
Thank you. Hello, everyone. Oops. I'm the Dr. Child that did therapy on Demosthenes Lorandos. So I'm really pleased to see my therapy worked. Quite a performance. I need to do some more therapy on his timekeeping because he's trying to stop the rest of us speaking. The bills, the invoices in the post. So yes, I'm a retired child psychiatrist, family therapist from Scotland. And the topic is how reforming family law will work. And I'm going to read an edited highlights of the full version of this paper, which you can read in full at that link, the tiny URL one. After many years puzzling, I want to share some radical thinking about family law and parental alienation. And this is not science, and there's about a half dozen other ways in which you can dismiss me if you want. But I think we need to consider this, because if we don't think deeply, PASG will perhaps fail to protect children from suffering and harm in all the ways that we might be able to. We risk becoming part of the problem. And 10 minutes is not enough to cover what's taken me 10 years to think through, so the long version covers some questions that will occur to you, and some points that I've called John McEnroe points, where you're saying, you cannot be serious, Dr. Child, you know. So you're going to think that at some points, but I think they need to more, those do need to be raised and have more discussion about them. So I'm continuing where I left off last year in Stockholm. I say we need to do two things: effective social marketing and reform family law so it simply upholds the law. I compare how we do schooling with how we do separated families. I look at three trends, then what family law isn't and is good at, ending with a summary with evidence. A little bit. This is about Scotland that I know. There will certainly be major differences across countries, but I think a lot of issues apply everywhere. You hear that in all these presentations. It may be that ruthlessly adversarial family law in the US is a especially hard case for reform. First real credit to all the essential groundwork of armies of us, legal and helping professionals, researchers, activists, and sufferers, all well represented here in PASG. This kind of clamor from those trying to tackle a problem tells the world about the nightmare of parental alienation. It's the same with any major scourge. Take a disease like cholera. In years gone by, victims and medical teams treating them had urgent frontline work to do, and then to tell the world to get something done about it. But the real answer to cholera is not the frontline treatment that victims and medics call for. Cholera is prevented by sanitation, not by medical teams and treatment. The medical teams may lose their jobs when sanitation cures it, prevents it, but they don't resist this welcome progress or grieve. They throw a party. So the question I would have is, are we ready to party when we find the sanitation that prevents, sorry, have I pressed on things? When we find the sanitation, perhaps, that prevents PA? Or do we just send PA back to drink dirty water? Family law has so far been the equivalent main frontline system for the scourge of parental alienation. But we all know that on its own, most family law, present company accepted, including Demos, Most family law is not competent for that job. It's like pouring fuel on a fire. Family law courts improve their competence by recruiting in-house, as it were, in their territory, qualified allied professions to do that frontline, help do the frontline work. And that means a rare few of the thousands of the world's parental alienation cases are pulled out way downstream. Even so, this rare heroic success can hardly claim to have prevented much harm and distress for those cases, let alone the vast majority of cases in and outside family law. That's why I call this non-therapeutic family law. We're trying to be therapeutic, but we're not. Present company accepted. So, to summarize, what's happening as with cholera epidemics, the present non-therapeutic family law system, together with competent professionals and traumatized clients, treats a few cases, raises an important frontline clamor like we're doing to the world, and that clamor first needs to be turned into effective social marketing until awareness raising works and until the case is made and built, including the John McEnroe points. Radical reform of family law is not an option. We're all stuck with clamoring and tinkering and doing our best with what we've got. And today I'm making the case, beginning to make the case, for radical reform as an option. How do we do schooling then? So let's compare this. With our children's schooling, our laws team up with what we all universally and automatically agree is good for children. We require all children to go to school until school leaving age. Whether the child likes it or not, and whatever the parents' limitations, the parents expect or are expected to take full responsibility and to get help if necessary to work out any hurdles and risks to ensure their children get their schooling. However mature the child, however small or big the concern, never ever does anyone consider, mention, or promote breaking the law by supporting no school as a final solution. Though there are laws, the universal expectation means that all kinds of other things happen, so that the law is not the first place people head when children refuse to go to school. As a last backstop, the legal system is there as a reflection and reminder of what everyone agrees is right. How do we do separated families? That doesn't happen when children refuse a parent after separation. There are laws that say the same sort of thing as for schooling. Each separated parent has a responsibility to support their child's need and right for a full family life, including their relationship with the other parent. In public law, even if you have abused your child, it's a major legal step to stop your contact and relationship with your child. In Britain, anyway. When parents find reason to break the law about parents having a responsibility to support the child's relationship after separation, non-therapeutic family law does almost everything except uphold the law. Present company accepted. Parent refusal is in every respect dealt with as in diametrically opposite ways to school refusal. Stand back. The present family law system positively welcomes the work from the start, takes responsibility away from parents, supports without challenging the prior unilateral decisions of the resident parent about the children, and the implied or explicit allegations about the non-resident parent. Then, family law hinders the non-resident parent's role and decisions, blocks any due process for properly dealing with any allegations, thereby ignoring fundamental individual rights and children's welfare. Family law creates and sanctions all kinds of new, quotes, crimes and punishments for parents and children that don't apply under public family law. If the state doesn't take children away, then no parent should be able to interfere with the child's attachment with the other parent, let alone have private family law sanction it. Family law systems pay loud lip service to the child's welfare as paramount, but seldom get close. They conflate two very different purposes, and again this may not apply in the US, they conflate two very different purposes, the child's voice, investigation of risk is mixed up with meaningful participation of children in matters that affect them. That's the kind of UN rights thing. Courts think it's a good idea to make the child's immature, unobjective voice key to which parent wins without wider assessment. Courts forget that children and young people are unable to answer major hypothetical questions about their own long-term future. The processes of family law actively prevent the kind of prompt, flexible, engaged, collaborative, solution-focused frontline services of the kind given for school refusal by teamed-up, qualified, competent, multidisciplinary professionals at the point of need. John McEnroe point. Okay, they may not do it very well sometimes, some places, but that's at least their job. Where effective legal systems depend on firm consequences for breaking the law, in non-therapeutic family law, firm consequences are remarkable by their absence. Non-therapeutic family law enables everyone to game the system without consequence, including agencies, by the way, and it may miss those who are not gaming it. Okay, that's my picture, at least in Scotland, of what family law looks like. 3 key trends that have influenced this. The epidemic of family separation and divorce and the celebration of single parenthood in recent decades has resulted in a dominant cultural view that having a relationship with both parents and their extended families after separation is way less important for children than schooling is. Second key trend, the horror of abuse and risk to children is a major, valid, modern concern. But understanding of abuse is poor, and family law doesn't deal with it competently. Present company accepted. 3, all of us and parental alienation folk are as bad as any, and with some good reason, but there's a broader picture than the kind of cases represented here. All of us happily accept the mob's scream that a parent who is the slightest bit abusive to their child should be evaporated instantly and forever. Yet we know that even when a child has been abused, the child and likely the parent too still hold on to their attachment. As competent social workers should do, problems need to be carefully assessed and attended to in each case, repaired if possible, not denied and sidelined. The child's relationship with both parents is carefully sustained throughout, or the nearest thing you can manage. That protects all children and disarms any use of the so-called nuclear option. We heard a case where contact was sustained through an investigation and the result was a positive relationship was still present at the end of that. Can't remember when we heard that. So what aren't lawyers and courts good for? First, they're not set up to be a frontline agency. They're not the right place for first assessing and sorting problems, managing risk, child protection, emotional abuse, mental health or personality disorders. So, serious allegations should not be allowed into family courts to become the smoke that no one blows away and which chokes up the proceedings. Those making the allegations should be directed, if they're serious about them, to the relevant and competent agencies, the agencies that should be competent, but they aren't competent partly because they can trust that they can game the system and hand it back to family law. But if that's stopped, they would have to become more competent. No family court should be sanctioning a parent's decision to interfere with their child's relationship with the other parent when public family law would not. Secondly, neither are lawyers and courts the competent agency as first port of call to bring in and coordinate other agencies. Brian talked yesterday about how he does a pretty good job to try and do that coordination, but he does it for the purpose of winning in court. That's not the same thing as trying to work out what's best for the child's welfare. What could family law do well? What the law does naturally and well, as for schooling, is to set out and require us to abide by the law of the societies we live in. To state the obvious, a legal system is there to uphold the law. Where necessary, for those who don't abide by the law and with progressive authority, typically all other kinds of law, courts make determinations that include mitigation, chances to do better, probation, supervision, threats of increasing consequences for those who don't do better. It is not a court's responsibility to do more at the start than remind those customers who need help to abide by the law that they can themselves go and obtain that help from competent other agencies, knowing that the court is going to take action in a couple of months' time if they don't. Now, I know that's a John McEnroe point to discuss. This return to what I'm calling reformed family law returns to parents and to established outhouse agencies the functions it has typically tried to duplicate in-house. This solves, by bypassing it, the endless, unrealistic call by parental alienation experts and many others for courts and everyone in the world to learn more and more about parental alienation, and so on. The system will work when the law does what it's good at and stops trying to do what it's not good at, when parents are set to do, made responsible for what they should be doing, and when other competent experts do what they should be good at. Once it's clearer who should do what, then we can work on any remaining gaps in competence we may find in the ranks of those who should be competent. So to round this up, once effective social marketing has done a better job of awareness raising, that's the first step. The world needs to know that something has to change. The simplest, comprehensive and preventive solution, I say, is reformed family law. Reformed family law is very important, very powerful, very minimal. Reformed family law is essential for integrating formal law and society's values as it should, as it does for schooling. Reformed family law will be a rarely used backstop that expects and requires parents and other agencies to be responsible for sorting the problems so that they uphold the law as we do with schooling. The legal system will be left with little more to do than carry out some consequences, and quite promptly things like transfer residence. So we get that in place, but much quicker, with much less distress and harm. Evidence. Good idea, you may say. Well, I say there's evidence already available. Here's what family judge Philip Marcus said about his project in Israel. And he has reservations. He says, look, it's still a pilot project. I can't, but I think it's important to note this. He says, it's a draft paper, an additional contribution of the pilot program has been extensive attention in the media, both because the procedure is new and swift, and because the penalties threatened and imposed on alienators are unusual in their severity. In this way, perhaps paradoxically, effective tertiary attention to the phenomenon assists in primary prevention. What he means is, as soon as you start imposing consequences efficiently and quickly, the world gets to realize that the game is up and they've got to behave differently. The effective bit, I say, is very straightforward. It's a system that simply, swiftly, and reliably upholds the law and is known to uphold the law. Most importantly, it's a system that will use consequences when necessary. And it's all in the law. We hear all these, this conference, we've heard several presentations. The law already contains what you could do about these situations, but it never does. When that's in place, everyone knows the score and what they need to do without years of miserable, expensive, frequent visits to lawyers and courts. I'd welcome your feedback. Thank you.
Well, thank you very much for being here. A real honor for me. And my apologies to Tom. He received presentation at any time of the day and night, and he reacted without offending me. That was great. When you have a presentation at that time, at the end, do you understand me? Yeah. Louder. Come on. Yeah. Oh, that's better. When you have a presentation at that time of the Congress, you have the impression everything has been said, but not by everyone, and that's where I come. So let's move on if I can. Yes. I'm going to present the situation of parental alienation in German courts, but concerning the German legal system. So there will be three parts: German legal system and jurisprudence, because, well, that's a common law country here. So we want to stress and focus on the jurisprudence. What say the court about that? I was 3 days ago, I was moving around Philadelphia and I found this monument. That's a family. You see? A real complex thing. And, well, once I was in Germany and I asked my audience, and my audience were social workers and attorneys and judges and, well, every professional concerning families. So I asked them, ladies and gentlemen, would you entrust your own family problems to your family law system? 200 people. Okay, I will tell you the answer later. But what would happen if I answer here, if I ask you? But what do you think? I'm only asking the experts, the professionals that know the system and work for that. Would you entrust your own family problems to the system you're working with or for? So you are the experts, and they were the experts in Germany. The answer was nobody. Nobody raised their head. Nobody at all. So the people that knew the system at best don't trust their own system for their own family. Is it unusual? I said yes. If I were a medical doctor, I would trust my hospitals or my colleagues. If I were repairman for my car, I wouldn't trust my car to my colleagues as well. So I wouldn't trust my own family to the system I'm working with. Why? Well, that's part of the problem. You don't have much time, and there are many problems in order to find a solution. And I want to make a difference between a decision and a solution. If you go to the law system, you will get a decision. Is this the solution of your problem? Probably not. Have you seen the family statutes show you how complex it is? And then you have divorce, which is much more complex. Judges in Germany are heroes. They invented the Kaka Model. We talked about it yesterday. It's not relevant in the US, but in Germany and all over Europe. And they try to implement it all over the world. It's not happening now in Germany, but that's the second part of the story.
Could you please briefly explain the Kaka model for people who are not in the legal track?
The Kaka model was introduced in 2002, something like that, in a small court in Germany called Cochem by a judge, Jürgen Rudolph. And, well, he saw the system, family system, is controversial, adversarial, and harms more the children that work for them, exactly the contrary of what should be. So he tried to make a round table with all the experts, with the parents, to find a common solution. So this is a very good thing, you would say. But now in Cochem, Judge Rudolph is not a judge anymore, so the system is not applied anymore in Cochem, and in Germany it is disappearing more and more, which is very sad. They introduced from nothing. In Germany, you have a continental law system. So you need a law, and this law is written and should be applied by the judges. But if you are creative, you can find a kind of common law in Germany. Without a law, some German judges introduced guardians ad litem where there were no allowance to do that, or even access custodians. Both are my jobs in Germany. This is why I'm presenting them. Access custodians, would you understand that? So I am in charge of enforcing a court decision in a family system. So if a parent say, I don't observe this or that, I can force this person to do that. I have the power to do that. But sometimes judges are not that. Well, I think I skipped that. That's the symbol of justice in my hometown, which is really interesting, you see? It works. The scales and the knee. Justice is one to have a look. And the sword is really long and ready to hit. I say, well, perhaps that's family law. And another important thing is I make my PhD in law, and I had the impression, what happens here? It's like a family law is kind of an island, which its own system. You can say the truth or not, nothing happens. You can respect decision or not, nothing happens. So it's well, it's only in family law, and I have the impression it is all over the place like this. Short intervention for that. Parental alienation, I wanted to find a no decision. I said parental alienation, at least now in modern times, you need a family court in order to say, yes, it's a process that ends with a syndrome. This is relevant because it will make the difference in criminal law between an endangerment offense means just to do one thing jeopardizes something you want to protect, and a result offense. It means either you have the result or there is no crime and no punishment. So parental alienation per se would be endangering. If you have a syndrome or not, I'm convinced now it is a syndrome, but even if you don't, it will be punishable, should be. So this would be a change to parental alienation normal case. You have a parental conflict, an imbalanced influence of the child, of one parent, on the will of the child, and you listen to what the child say, and then you have a court decision, and then the court say parental-child contact suspension for 2 years, 3 years, again 2 years, and then you have parental alienation. It shouldn't be. In Germany, we have a constitution. And look, there, the care and upbringing of children is a natural right of parents and a duty primarily incumbent upon them. Shouldn't be. And which are the fundamental rights of children to their parents? Then you have human dignity or the free right to free development of his personality, of the child. So we are talking about fundamental rights. For not jurists, this is the highest protection level at all. This is the foundation of democracy, the rights of the citizen, and not the contrary. We have a civil code saying the best interest of a child, as a general rule, include contact with both parents. Well, principle of proportionality, logical, and what happens if somebody doesn't work for that? You will have an administrative fine or even detention. You can go to jail. It says the law, or you can surrender persons. You can take persons away from where they are, in theory. As far as I know, it never happened. As far as I know, there was never a detention. As far as I know, fines are extremely rare. They happen, but they're extremely rare. The last case I know is a woman earning 15,000 euros a month and received a fine of 2,000 euros, which for her is some kind of peanuts. And she appealed, and the fine was deleted, so nothing happened. I told you about criminal law. So in this case, you can go to jail. If you admit parental alienation is a syndrome, then you will have a harm, and you can commit bodily harm, because emotional, psychical damages are a harm. or what happens with 171 criminal code if you violate your duties of care, you influence unduly your child against the other parent, you commit that crime. And I said, is this just my impression? Because it was never applied. So I asked the Staatsanwaltschaft. It means advocate of the state. And the answer was, yes, you are right. It was never applied, but if somebody tries, it could happen. Abductions of minors, if you admit there's a trick, you know the system, how it works, well, that's a secret. If you want in Germany parental alienation to happen, it will happen. Nobody will stop it. I can show you how. It's really easy. I think every lawyer knows that. It will happen, even if you have all these protection laws. But if you know the system and know how it works, so it is a kind of deception and then abduction, in theory, you can change from family law to criminal law, and perhaps you are lucky at the criminal court. Okay, I told you it shouldn't happen. And what about jurisprudence? And then we move to the highest court in Germany. Highest is not hierarchical. This is the only code, the only court in Germany that is above everything. The only court able to interpret the Constitution. Bundesverfassungsgericht. And there is a case on parental alienation. Okay? You can close your eyes, you can believe me or not, but this is the foundation. Look, you have to consider the will of the child even if it has been influenced. Only if this influence do not correspond to the child's attachment can be left and considered. Funny. You understand that? It means father influence child against mother. Child say, I don't want to see mother. This will has to be considered. Child say, I don't want to be with father. He's living with. This will is not to be considered, which is very unusual because the parent which is outside is the one which is taken away. So thrown away. You see, that's not logical. But why do you have to consider this will of the child? Profoundly scientific. If you do not follow the will of the child, it may experience loss of control and reduce his or her self-efficacy, which could lead to physical disturbances or behavioral disorders. So it's not the contrary of PASG. It's absolutely a deletion of PASG. So you harm your child when you don't respect the will that has been influenced. It is constitutional court. I'm not inventing that. And that is, what? Sorry, I have to speed up. But 5 minutes, please, 3 minutes. It's like a bazaar in Turkey. So, under this circumstance, the child experiences himself coercive measures against the mother in order to fulfill the right of access of the father. Besides, it will make it worse. So, you put pressure on the mother, in this case, you put pressure indirectly on the child will identify with the mother, and it will be worse for you. You understand that? Ridiculous. Lessons. PA is a sure win. Keep calm and do not give up. You will alienate the other parent if you really want. Do not be a troublemaker. The non-resident partner makes it a troublemaker by claiming everything works worse. He doesn't know why, because he does not respect the child's will, even jeopardizes the child with his claim, and disturbs the family peace. It is really like this. What do you think? So maybe it is not right to exert influence on a child, but what can we do? Would you separate a child from this symbiotic relationship with the mother or the father? No, you're harming the child. That, I swear, that's the German logic. And they're very logical. Well, salvation, I don't know if I'm still 2 minutes. MOOC in Germany, that's the highest European court concerning human rights, fundamental rights. So this is the European Court of Human Rights based on the European Convention on Human Rights. At the end of the day, Germany has been condemned many times. But you have to imagine, you have first level, second level, constitutional level, then European level. So perhaps you're right, 6, 7, 8 years later, at cost I cannot imagine, time, energy. But perhaps in the end you are right. So he was right in the end of the day, and the court invented a new view of Article 8 of the Convention. You read that with me. Everyone has the right to respect for his private and family life, and there shall be no interference by a public authority. So it is a defensive right. In this case, the court reacted very positively and said, if the German authorities allow that a father hasn't seen his child for 4 years, prima facie means he didn't do his duty, the positive duty to protect the family. And Germany was condemned. Okay? It's only 5, 4, 6 cases where this happened. It's an exception, but it's like this. So there was a violation. And, well, I don't know, I could speed up. If I have 1 minute, I finish that. I wanted to tell about my experience. If you cut from the imbalanced influence of one parent to the will of the child, you will stop parental alienation. And you can do that. That's my job. I cannot say how many parents I've protected like this, but you only cut that and you will have no parental alienation. So, for example, children under 7 in Germany, the will is void, even if it's considered in family law. I told you family law is an island with their own system, but it's considered. I can say that. How about the will of the child? The child is a subject of law, but not right enough. This is why there is a right of custody. It is not logical that you give this child needing a custodian the power of eliminate the custodian. But this is exactly what you are doing. And what do a child know, not at 7 or 6, but at 8, 10, 12, 14, or 16, about eliminating one parent? It's impossible. They know what they're doing at that time. So I understand we have to respect the will of the child, but we cannot doing that, doing exactly the contrary, promoting its discrimination or their discrimination. And how about the words of the child? And I'm finishing with that. The clearer, that's my experience, the clearer the words are helpful, the words of a child are, the more probably they are not their own. So if a child say, I just want to see my mother 4 hours a week, Mondays from 2 to 6, probably, if the child is 10 years old, it's not their own will. Oops, sorry. If you have the impression of words are ordered words, or the constellation, normally the non-resident partner is the rejected one, or it is not logical. So the less contact, the more rejection, it is not logical. How about the inconsistencies? So long-term memories of a child. Well, I stop. And how about the last one, inconsistency? If a child talks about fear, being abused, but show no reaction of angst, of fear. So it's not logical. So you have to see the whole picture. I have to finish. I thank you for that.
Hello, everybody. I am a judge in Belgium, a lucky judge. I'm not a hero, but I try to help parents to make the best, to take the best decision for their kids. I don't like to make decisions. Sometimes I have to, but I think, yes, I think like the other participant told you that we don't have to make the decision for your kids. They are your kids, you know them, and I don't know them. I don't like to choose a school for them because it wouldn't be my choice. And often I say to the parents, you do want me to choose a school. I won't do that. But I'm going to explain why I won't do that, because I have some tools to expose you very fast. You know that in Belgium it's raining, but you don't know that it's raining pearls. Rain pearls. All these excellent laws that have cleaned up and refreshed the legal landscape since 25 years. First of all, the law of 13 April 1995 on the joint exercise of parental authority, even in the event of the separation. It's important because in Belgium, 98% of the parents can decide together and take all the important decisions together. There is few exceptions, like in all the countries, because communication is not possible with a parent that has disappeared, a parent that doesn't want to take decision, and things like this. The second important law is the one of the 18 July on 2006, tending to favor the equal parenting, equal custody. We are following Sweden from very close, because we have around 65% of share parenting. It's not the solution. It's not preventing alienation, but I think that it's reducing a lot of alienation. And parents has the right, but the kids has a right too, and we have to balance both rights. We have also, since 2007, the divorce without fault. It's really fast. We can be divorced in 3 or 6 months, and you don't have to fight in court. So it's better for everybody. And what concerns the alimony, it's based on the needs of one or the other parent, not on the fault. The most important law was the law of 30 July 13, establishing the Family and Youth Code. The big principle was one family, one file, one judge. Thanks to this principle, we know very much our families. And thanks to the referral, permanent referral, parents can say to me every time there is a new element in the family. So as I have taken all the decision for this family, I know they can't lie to me. I know everything of them. Though we gain a lot of time with this solution. This law has also favors the alternative methods of conflicts resolution, you know them. And what is special in Belgium, they have created the amicable settlement chambers chaired by a judge. This is, you don't have to pay for it. And so if you want to have a paper, you can go to the court and say, okay, we get an agreement and we are going to talk about this with you to see if it's perfect. And sometimes the judge is going to take 1 hour to help you to make this, it's not a judgment, but it's kind of agreement, official agreement. And one of the very important element is that we have speeded the proceeding. The deadline for fixing the application is 15 days maximum, but if it's very urgent, it's possible to shorter this delay to 2 days. Alors, we have 2 new laws in 2018. It gives the new tools for the lawyer and for the judge. The lawyer have to tell the client, okay, what do you do before going to the court to find an agreement, a consensus? They have to push them. It's in the law. It's an obligation of the lawyer. They have to inform their client about the fact that they have to try to find a solution. If not, I can send them to the chamber of amicable settlement chamber.
Judge Carly, I have a question. How do you deal with an alienator who is not participating in good faith? Because they will delay out, they'll take time to try to reach an agreement when they are not there to make an agreement in first place.
Okay, with a parent who is not respecting the agreement, first of all, when I see that a parent is not going to respect the agreement, it's not difficult to see, then I make this, I say, okay, we are going to see if you respect it. I'm going to see you in 2 months to see if you did respect it. But if you did not respect it, in family law, I have the power to order a penalty. And in criminal law, it is possible also to pursue and to be condemned to not respecting the decision I've taken for them. But usually people don't go to the criminal law. Usually it is the prosecutor. What I forgot to explain you that we have the luck to have in some hearings the prosecutor. For the difficult case like parental alienation, I have the choice to put this case in form of an hearing where I'm present with the prosecutor. And the prosecutor, he can take the decision to sue this parent for not respecting the decision. In the family court, the penalty can be very high. I have all the latitude. I can choose what I want. So usually they don't want to get a penalty, and they respect. And they know also that if they do not respect in Dinan, because we have spoken about the Kaka Model, in Dinan I have adapted. I won't be long because Ursula Kujou last year explained it, and also George. but you can also refer to an article of Nick Child on his site, and it explains how this system is based of two axes, interdisciplinary and also a rapid and efficient management of the case or the situation. It's called the orderly cooperation. So in Dinan, we have changed the role of the lawyer, the role of the judge, and the role of the expert to work all together. We all try to responsibilize the parents of the suffering of the children. The judge is going to be clear. Parents have to dialogue, they have to communicate. We won't accept any broken tie. To avoid the conflict, we have simplified requests. It means that you have to make a cross. Yesterday I gave some requests, but if you want some, I can give you. In the first hearing is going to be the decisive hearing, because it's going to be fast. I have 16 files by hearing, just for 3 or 4 hours. But the lawyers have already done the job with the client. They know how we are going to work, how to order an agreement. It can be a provisional agreement, a partial agreement, but without dialogue, we won't arrive to a solution. For the very heavy case, we have this expertise called the collaborative expertise. This collaborative is born from the dissatisfaction of the classes expertise, because this expertise takes time, and you don't have time when there is a parental alienation. It needs the cooperation of everybody again, the judge, the lawyers, and the experts. You are going to phone the expert to have a really fast rendezvous appointment, and the expert is, the parents are not collaborating, is going to write me a mail. All the reports are sent by mail to be very fast. And if the parents do not collaborate, they ask for the lawyer to come and help the parents to collaborate. In case the expertise doesn't work, but it works for a great amount of cases, then I will be obliged to take a very heavy decision. If one parent asks me, I can switch the custody. I can also condemn of a penalty. And to finish, we have an interdisciplinary youth commission. This is the solution. We know each other, we trust each other. We met every month, and we introduce reciprocal trust. There is every time a new subject, new people, they come to introduce them, and we organize conferences like about parental alienation and a lot of other subjects. For the European, don't forget, we have a very important resolution of the Council of Europe, and this one just encourage the state to promote multidisciplinary cooperation based on the Kaka Model. So for the Americans, it's different, but in Europe, there is no excuses. And the good news is that in the Valais, Switzerland, they are going to implement the model of Kaka. Even if in Germany it doesn't work anymore, what is true, it's depend of the personality of the judge. And I do hope that more and more judges are going to work like this, and will go on with Dinan and with the Valais. Voilà. It's just a question of mentalities. So Thanks about it.